Welcome to Ekam IAS. I am Fatima Nusrin. Our today's topic is Medical Termination of Pregnancy Act. So, why we are discussing this act today is that, as you all might have known, that the US Supreme Court has struck down the right to abortion recently. So, in the Roe versus Wade judgment, it has legalized this abortion in United States, but this recent judgment has struck down that legal right of abortion. So that is why we are discussing in the abortion law in the context of India, because that is what is relevant for your prelims examination. So that is why we are discussing about the Medical Termination of Pregnancy Act. So this is the prominent act in India that decides about the legality of abortion in India. Okay, so before moving into that topic, let's see the legal status regarding abortion in a global scenario. So, as of now, there are 24 countries that made abortion as illegal. So, currently there are 24 countries that make abortion as illegal. And according to the report or the estimation of Global Advocacy Group, which is a Center for Reproductive Rights, they have made an estimation that within these 24 countries, around 90 million or around 50% of women with the reproductive age reside in these 24 countries. Okay. So, among these 24 countries, some of the important countries are Senegal, Mauritania, Egypt in Africa, then Laos and Philippines in Asia, then El Salvador, then Honduras in Central America. So, in Central America, El Salvador and Honduras. Then in Europe, it is Poland and Malta. In Malta, it is the only European Union state or country that bans abortion in all circumstances. So, this is the legal status of abortion in a global scenario. Alright. So, now let's see the legality or legal status of abortion in the context of India. Okay, the Medical Termination of Pregnancy Act. So, this is one of the important acts that determines about the legal status of abortion in India. So, this was passed in 1971 when India made little more progressive or advancement in the field of medical science, as well as we found out more safer method for abortion. So, we enacted Medical Termination of Pregnancy Act 1971. The aim of the act is to improve the health of women and thereby making more empowerment to the women. Also to provide universal access to reproductive health services. So this act was passed in 1971. So now we are in 2022, right? So the ideological change as well as the advancement in our medical science field, as well as the nature of women in the society, or the character or the way of living or standard of living in the women of the women in society has changed, right? So we need further improvement in our act, and in order to provide more universal access to reproductive health service as well as a comprehensive abortion care or health care for all women. So for that, again we made an amendment very recently, and that is the Medical Termination of Pregnancy Amendment Act 2021. Then, so let's see what are the amendment made to the earlier act. When you study the act, you have to compare the earlier act with that of the amendment. But here I am doing, we'll first discuss about the 20 features of the 2021 act. Then later we will compare the similarities and dissimilarities between these the earlier act as well as the amendment. So the amendment has extended the duration to 20 weeks. If a woman got pregnant, then that pregnancy may be terminated up to 20 weeks in case of failure of contraceptive or contraceptive method or devices. And this is applicable to unmarried women as well in case of failure of contraceptive method or devices. So the age of the time period is 20 weeks. Okay, so we'll compare in the later slide. So you will understand that what is the extension or how the duration of extension. So this is one of the important feature, that is the time is extended to 20 weeks. Then regarding the opinion needed for the termination of pregnancy, this was added through the amendment. So for getting opinion, that is up to 20 weeks, if a decision regarding the termination of pregnancy, if that duration is 20 weeks, then one registered medical practitioner has to recommend, or their opinion is required. If they suggest that termination or abortion is required, then they can do abortion if it is up to 20 weeks. Then if the gestation period is more than 20, up to 24 weeks, that is from 20. Here the first case is 20 weeks. 20 weeks. In case of 20 weeks, only the opinion of one registered medical practitioner is enough. But in case of 20 to 24 weeks, then two registered medical practitioner needs or they have to give opinion that this pregnancy has to be terminated. Then if it is more than 24 weeks, then a state level medical board has to be constituted, and this board has to recommend that, or they have to say or make opinion that this pregnancy has to be terminated. So these are the conditions. In case of gestation period of about 20 weeks, recommendation from one registered medical practitioner. In case of 20, more than 20 up to 24 weeks, it need two registered medical practitioners' opinion. Then more than 24 weeks, it requires state level medical board's opinion. Okay, that is regarding the opinion. So we have seen the timeline or the duration for getting opinion. So we have seen till 24 weeks. So the gestation period has, they have increased the gestation period or upper limit of gestation period to more than 24 weeks for special circumstances and for special categories of people. And these special categories of people are, there are 7 specific categories of people, and for them, if their gestation period has bit more extension, that is, even though it is about 24 weeks, they still can opt for abortion. And these people includes the survivor of sexual assault or rape, then minors, then who has got divorced after being pregnant, then or being widowed, then physically disabled people, then mentally ill women, then fetal malformation. If there is any risk associated with the baby, then abortion can be done. Then women in pregnancy in humanitarian settings or disaster or emergency situations. So these are the categories where pregnancy is allowed after 24 weeks of gestation period. Alright. So these categories, especially these 7 specific categories is important. They may ask that who are these special categories of people. So you should know all these categories, specific categories. Okay. So confidentiality, under confidentiality, the name as well as any other details regarding the women will not be disclosed except the authority who is interested for this purpose. Other than that, their name or any sort of details will not be revealed to anybody. So the privacy is ensured. So in the Puttaswamy, the very famous Puttaswamy versus Union of India case, the Supreme Court has held that the decision to be pregnant or not comes under Article 21 of the Indian Constitution, the right to privacy, that it's a part of right to life and personal liberty, which is enshrined in the Article 21, which is a fundamental rights. So it is a fundamental right in India under Article 21, and this was made clear by the Supreme Court in the famous Puttaswamy versus Union of India case. Okay, so now let's compare the original act with that of the Amendment Act. So we have seen it separately. Now let's compare so that you will be more clear regarding the act and the amendments. So earlier act, that is 1971 act, it was applicable only to the married women. So now we have seen that it is applicable to both married as well as unmarried women. Then we have seen the maximum or upper limit of gestation period was 20 weeks. Then in the Amendment Act, we have seen that it has, 20 weeks was the original, then 24 weeks for the special categories of people. We have seen more than 24 weeks is applicable. So regarding the medical practitioner or opinion from the medical practitioner, earlier opinion from one medical practitioner was required for the abortion till the gestation period of 12 weeks. Now it has extended to 20 weeks. Then from the 20 weeks we have extended to 20 to 24 weeks, and we know that there are then after 24 weeks there is a medical board, a state medical board, their opinion has to be taken. And regarding the punishment or fine, it is earlier rupees 1000, now it is fine as well as or the imprisonment of about 1 year. So these are the changes made to the 1971 Act, and the amendment was made in 2021. Okay, so that is regarding our Medical Termination of Pregnancy Act. I hope this is clear for you. We have discussed the constitutional provision regarding it, and we have seen both the Act's initial act as well as the amendment, and we have made the comparison. And yeah, that is it. And this is the model question for your today's topic. And try to find the answer for this question and write the answer in the comment section below, and the answer as well as explanation along with its material will be provided in our Telegram channel. The link to our Telegram channel is given in the description below. So that is it regarding today's topic, and if you find this video helpful, please don't forget to like, share and subscribe to our YouTube channel. Thank you for watching.